Welcome to immigrationquestion.com, your go-to resource for U.S. immigration insights. We provide clear immigration news and information. Our platform provides a network of licensed attorneys who can answer your questions and guide you through the process. From visas to green cards, asylums to citizenships, immigrationquestion.com helps you to network with immigration attorneys so that you can move forward with confidence. Sign up today or download the app. Free registration, limited time offer. Stay tuned. We go live in 30 seconds.
Hello everyone and welcome to the special edition webinar hosted by immigrationquestion.com, a networking platform and meeting ground where immigrants, families, advocates and licensed immigration attorneys come together to understand U.S. immigration policies and procedures better. I'm your host, GB Satusa, for this important discussion: conditional green cards explained, I-751 filing, extensions and interview waivers. Now, conditional permanent residence is a unique status given to certain green card holders, often based on recent marriages or other specific immigration circumstances. While it allows lawful residents in the United States, conditional residents must take additional steps to remove conditions on their status to achieve full permanent residency. Understanding the I-751 filing process, employment and travel implications during extensions, and the circumstances under which interviews may be waived can help conditional residents avoid delays, RFEs, or potential issues with their immigration status. To help us break this down, we are honored to be joined by Sonu Lal, Esquire, an experienced immigration attorney who advises individuals and families on conditional permanent residence, I-751 petitions, and related family-based immigration matters. Attorney Lal, thank you so much for joining us today. We're thrilled to have you for this important discussion.
Thanks for having me. Happy to be here.
Now, before we begin, a quick reminder to our audience: immigrationquestion.com is a public educational and networking platform. The information shared today is for general informational purposes only and does not constitute individualized legal advice. If you are joining us from Facebook, YouTube, LinkedIn, or any other platform, welcome. Please subscribe and share this session with anyone who may benefit from understanding conditional green card requirements and the I-751 process. Now let's dive right in. Attorney Lal, can you explain what conditional green card and why some applicants receive it instead of a regular green card?
It's a very good question. Sometimes you will notice people who are applying for their green card based on marriage. Sometimes they receive a 10-year green card, sometimes they receive 2-year conditional green card. So what's the difference? Here's the difference. When you are entering to US or when you are inside US, you are appearing for your green card interview, if you have been married less than 2 years at the time of entry or the time of your green card interview, the green card that you will receive will be a conditional green card valid for only 2 years. But if you have been married for more than 2 years at the time of your entry or at the time of your green card, you will receive your permanent green card valid for 10 years. So there's a difference. If you get a conditional green card, you will have to file a petition to remove that conditionality on your green card on Form 751 before the expiry of your conditional green card. That's how this works.
Now, who is required to file the Form I-751 petition to remove conditions on residence, and when should the petition be filed during the conditional residence period?
It's a very good question. So 751 normally it's a joint petition, meaning you have to show that as spouse or as being married to a US citizen, you intended to live your rest of your life with that person. So you will be filing a joint petition, both husband and wife. And when you should be filing it, typically the conditional green card expires in 2 years. So 90 days before, or at least within the before the expiry of the green card, 90 days before that period, you should file your 751 petition when you're filing it as joint petition.
Now, attorney, what happens if the I-751 petition is filed late? And what are there any circumstances where USCIS may accept a late filing?
So generally, you should be filing your 751 application, but if there are any extraordinary circumstances you could not file it, USCIS might accept it what is called non-pro-tum, meaning they would accept it as a late filing, but consider it as timely filing based on those extraordinary circumstances. But again, that is very discretionary. Don't assume that your request will be accepted by USCIS. They may deny it also. If they deny it, there are severe consequences of that.
When might someone need to file individually instead of jointly with their spouse?
So very good question. Here is the area where the law becomes a little complicated. Let's say you get married, you file your green card application I-485, you got your conditional green card. But after some time, the marriage is not working out. Or maybe the spouse is abusive. Or maybe the spouse passed away. There can be different reasons. In that case, you will not be filing your 751 as a joint petition. You will be filing what is called 751 waiver. It will be the same form, 751. It will not be a joint petition. It will be a waiver. Waiver of what? Waiver of filing it as jointly. Now, the basis of waiver can be different. For example, the spouse passed away. That's one ground of that waiver. Another ground may be the spouse turned out to be abusive. So you cannot file it jointly, and you are requesting USCIS to waive the requirement of joint filing and approve my waiver as I'm the only one signatory on this application because my spouse is abusive to me. And then you will provide supporting documentation also.
Yeah. Now, what types of documentation are most persuasive when proving that the marriage was entered into in good faith?
So there are two parts of it. Let's say you are filing a joint petition. In that case, you will be filing documentation, uh, a lot of joint documentation, a lot of joint bank accounts, if you have joint lease or mortgage agreement, joint insurances, etc. And if you have traveled a lot, if you're living as husband and wife, you will already have a lot of joint documentation, pictures, if you travel together, etc. So meaning a lot of joint documentation. That's when you're filing the joint petition. Let's say you're filing a waiver of that joint petition. Even in that case, you should be submitting documentation that you intended this marriage to be a bona fide marriage. You wanted to live with that person forever. But but it turned out to be a bad marriage. But still, you will submit documentation showing that marriage initially was a bona fide marriage. And in that case, you would submit the joint documentation. Plus, let's say if the spouse is turned out to be abusive spouse, and let's say he was harassing you, torturing you, and you somehow maybe call the police on him. In that case, you will also be submitting police report and such other relevant documents.
Now, Attorney Lal, in recent years, many applicants have received long extension notices while their I-751 petitions are pending. How do these extensions affect employment authorization and travel?
It's a great question. This affects a lot of people. What happens when you file your 751 petition? You file it, it remains pending for a long, long time. By the time your green card has already expired. So can people travel? Can people work? What is their status during that time when their 751 is pending? So USCIS has clarified this. The receipt notice for 751 works as your kind of a replacement of your green card. What it means is, with the expired green card and with that receipt notice of 751, you can continue working. And even if you have to travel internationally, you can travel with that also. And they also extended the period of that 751 receipt, which at this time is as long as 48 months, because some cases remain pending for 2 years, 3 years.
Now, under what circumstances does USCIS waive the I-751 interview, and what factors tend to trigger an interview request instead?
So USCIS has discretion for waiving these interviews. In their discretion, they can waive those interviews. But in what cases will they waive those interviews? Generally, where you have provided very strong documentation of bona fide marriage and you have filed a joint petition. In those cases, yes, they may waive your interview and they may straight away issue the approval notice and then send you the permanent green card. In some
Now,
cases, they may not waive the interview where you have not provided sufficient or strong documentation of the bona fide of the marriage.
right. Now, attorney, looking ahead, what practical steps can conditional residents take to prepare a strong I-751 petition and avoid delays, RFEs, or complications?
First of all, if you are filing 751, file it timely. That's very, very important. And in terms of avoiding RFEs, in terms of getting kind of the waiver of the interview, I would recommend filing strong application, providing strong joint documentation. What kind of documentation you can provide? Of course, you can provide joint documentation such as joint insurance, lease, bank statement, photographs, travel document, etc. You can also provide affidavits from family friends who know both of you, stating that they know you, they know both of you for a long time, and you are happily married, and that you do intend to live together as husband and wife. This kind of documentation helps filing a strong 751 application. It also leads to avoiding or waiving off that interview.
Right. No, truly an eye-opening session so far. Thank you for those valuable insights, attorney. For everyone watching, this discussion about conditional green cards and I-751 process is not meant to create worry, but to encourage preparation and awareness. Filing on time, maintaining strong documentation, and understanding interview and extension procedures can significantly reduce stress and risk for conditional residents. If this is your first time joining us, welcome. ImmigrationQuestion.com is a networking platform where users can ask immigration related questions at no cost and engage with participating attorneys. We're also thrilled to inform you that ImmigrationQuestion.com is Triple B accredited and ISO certified, reflecting our commitment to transparency, accountability, community education, and security. Now, Attorney Lal, based on your experience assisting conditional residents, how does ImmigrationQuestion.com help immigrants and immigration attorneys such as yourself?
Well, I think it's a great platform for both parties. When I say both parties, meaning the immigration practitioners like myself and people who are looking to hire an immigration attorney, it connects both parties. I think it's a great platform.
Now, before we move into our live Q&A, let's tackle this important question. What is one misconception about the I-751 filings or conditional green card requirements that applicants should clarify to avoid unnecessary worry?
So there are 2 or 3 pointers I will give with regard to this question. Number one, what we have seen in our office, sometimes people miss the deadline of filing. Sometimes people do not know what kind of joint documentation or how much joint documentation they have to submit. And when they submit weak case, that leads to either RFE or denial. And number 3, people whose marriages are not working out, they do not know that they can still file their 751 application as a waiver petition. So that's so many people do not know whose marriages are not working out.
Thank you so much. If you're just joining us, we've been speaking with attorney Sonu Lal on conditional green cards explained, I-751 filing, extensions, and interview waivers. We are now moving into our live Q&A session. This is your opportunity to ask general questions and hear educational insight from a licensed immigration attorney. Please drop those questions in the chat or call us live at 516-703-3483, and we'll take as many as time permits. After filing my I-751, how long does it take to receive the receipt notice from USCIS?
Typically, the receipt notice comes in 2 to 3 weeks, but that's general timeline. Sometimes it may take longer than that also. And USCIS starting these receipt notices to be of a thick green paper. It's not a regular white paper. Normally, you will receive these receipt notices as a green USCIS, similar to approval notices.
Alright. My marriage has ended in divorce. Can I still remove conditions on my green card?
So if you've already divorced and it's been less than 2 years since your divorce, you can still file the 751. It will not be a joint 751, it will be a 751 waiver. But you do have that option. If you or anybody else is in that situation, I normally recommend talk to an immigration attorney, see what other option you might have, where the marriage has not been working out, the spouse is abusive, or you're already divorced, or you are still legally married but living separately. In all those cases, there may be few options for you, but then you should talk to an immigration attorney who can guide you further.
All right. If my spouse refuses to sign the joint petition, do I have any other options?
Yeah, this question is continuation of the previous question. Yes, if the spouse refuses to sign the joint petition, you may have options. But again, as I said, all these kind of cases are very fact and case specific. You should talk to an immigration attorney. Yes, you may have some options.
All right. What happens during the interview if USCIS thinks my marriage might not be real?
So when you go for the interview, either a 751 interview or for that matter, green card interview, USCIS might issue what is called RFE, request for further evidence. If the officer is not convinced that your marriage is real, they may issue either an RFE or an NOID, notice of intent to deny. And in that notice, they will explain what the objection is. And if you can provide any supporting documentation in response to that objection. And if you are able to provide supporting documents in response to that notice, your case may still get approved.
All right. Can USCIS deny my petition to remove conditions on my green card?
Yes, USCIS can deny if they are not satisfied with your petition. And what typically happens when USCIS denies a 751 application, they will issue what is called NTA or notice to appear. What it means is they will initiate removal proceedings against you. They will refer you to the immigration judge if the 751 gets denied.
All right. How long does it take to hear back from USCIS after filing Form I-751?
So after filing 751, you will receive the receipt notice within 2 to 3 weeks. But the problem is either the approval or interview scheduling. General timeline may be a year or so, but we have seen many cases remain pending for maybe 2 years, 3 years also.
All right. Now, Attorney Lal, recent reports indicate that the Second Circuit has confirmed that children must be under the age of 21 at the time of the adjudication in certain cancellation of removal cases. Court interpretations of eligibility requirements can have implications for family-based immigration filings and can affect timing considerations for related petitions. Now, when families hear about court rulings like this, that focus on age requirements at the time of adjudication. What should immigrants understand about how timing can affect eligibility in immigration cases?
Okay, so first understand the relief of cancellation of removal is only available when someone is in immigration court. And what is that relief? Essentially, your qualifying relative, in this case, your child, will suffer extreme and exceptional hardship if you were to remove. But under US immigration law, the definition of child is the child should be under 21 at the time the relief being granted. So let's say you are in immigration court, you file your removal of cancellation of removal application, and your child is maybe 17, 18 at the time. But it quite happened, these proceedings last several years. So by the time you are scheduled for your individual hearing, where the judge will decide your application, your child has already crossed 21. So in that case, the judge cannot grant you that application, and they will deny your application. That's what the Second Circuit did in this case also. Meaning, uh, by the time the judge could grant the cancellation of removal, the child was already crossed 21, which means that person was no longer a child at the time. Therefore, the application could not be granted.
Yeah.
Now, there is another law, CISPA, whereas normally it helps in these circumstances, but in other scenario, that CISPA doesn't help for cancellation of removal. That's what the Second Circuit did in this case. Now, if you are in a similar circumstances, what you can do is, if you are in immigration court, you can file a motion to advance your individual hearing so that the judge can grant the application while your child is under 21.
Hmm.
So if you are in immigration court, the child is aging out, maybe they are 17, 18, 19, you should file what is called motion to advance so that judge can hear your application or schedule the merits hearing while the child is under 21.
And how important is it for applicants to plan filings carefully when a child's age could impact the outcome of the case?
It's very, very important. Otherwise, your relief application will be denied if the child already turned 21.
Yeah. Yeah. Thank you to everyone who joined us for this special edition webinar. And thank you, Attorney Lal, for sharing your knowledge and practical guidance with us today.
Thanks for having me. Thank you.
You can always visit immigrationquestion.com to ask immigration related questions, stay informed about policy updates, and register for upcoming live events. If you missed any part of today's discussion, the replay will be available soon on Spotify. Just search Borderless Talk by immigrationquestion.com. We look forward to seeing you on Wednesday at our next live session. Until then, stay informed, stay prepared, and stay connected. Bye bye.